Okay, it's 3:17. I said they come back at 3:15, so hopefully people are coming back in. We have, by my count, 5 more things to discuss. A couple action items. So let's get started.
I'd move to approve.
Governor Peterson?
Yeah, I'd move to approve.
Just prove everything.
Second.
I might win. I still might win that. Well, I guess I won't win the fastest meeting, but I'd only be an hour over. All right, let's start on. There's a bylaw amendment, first read. And there's a couple bylaw amendments. Both of them are first read. The first one is Article 5A1 regarding the Budget and Audit Committee class representation clarification. You'll find that on late materials, page 66. This rose its ugly head this year, and due primarily to my fault, not understanding how many members were supposed to be on the Budget and Audit Committee. Apparently last year it operated with 8 members. This year, according to the bylaws, it should not have, but is operating on 7 members at the time. The purpose of the amendment is designed to return the committee to 8 members and change the bylaws to allow that to happen. And it's I think there's a change of 6 words or 5 words altogether, very short amendment. And without reading the memo, you can read it. So with that, I'm going to I see that there are some little blue hands raised. So let me get ready for discussion. And I have Governor Williams-Ruth first on the list.
Thank you, Mr. President. I had spoken with General Counsel Shanklin regarding a concern that I had pertaining to 8 members, given that 8 governors is a quorum of the Board of Governors. And she advised me at the time that the Budget and Audit Committee actually has its own OPMA requirements that it does. Given yesterday's training, I want to ask another question of General Counsel Shanklin, if I may, regarding though there is a budget and audit OPMA requirement that's fulfilled through its normal publication, does that also then mean that there has to be a secondary notice that a quorum of the Board of Governors is meeting, though they're meeting for this? And I'm not sure if I'm able to explain it right, but it's like budget and audit, even if there were only 4 members, they have to comply with OPMA for what they do. But now that it's going to be budget and audit, plus now a quorum of the Board of Governors, does that raise the need to have 2 OPMA notices, so to speak? So I hope I'm expressing my question correctly. Thank you.
General Counsel Shanklin.
Yeah, so the way I understand your question really is, if a majority of the governors meet at a committee, is that considered both a committee meeting and a Board of Governors meeting, and therefore you would need to notice both? Is that it? Okay, that's the way I understood your question. That is a good question, and I'm not sure off the top of my head that I could really provide you an answer. Off the top of my head, I would probably say, since you're not meeting with the purpose to intend to take action as a Board of Governors, probably 2 notices are not necessary. But it is an interesting question when a committee of the board has a majority membership of the board. But I will continue to look into that question and update or correct my statement if necessary.
Thank you, General Counsel Shanklin. Does that answer your question, Governor Williams-Ruth? Okay. And I don't know, point of order, question for us. This is on first read, so theoretically we're not acting today. I suppose that if folks were not of the opinion that we should move forward with this, we could have a motion to not proceed forward. Is that how that would work? I don't know if I should direct that to Executive Director Nevitt or Parliamentarian Stevens.
Mr. Chair, a motion not to proceed forward. Normally that would be a motion, for example, to postpone. You could also decide to take no action, but a motion not to proceed forward. Well, those are the ways you would not proceed forward. But by the way, going back for a minute to General Counsel, at least as I understood the training, one, your notice explains exactly what that entity is to do. And so you would be in violation of the OPMA if not only did a committee meet, but simply because it had enough members, then acted as if it could also take actions that would happen in a Board of Governors meeting. So if your notice says this is a committee meeting and the committee is going to make recommendations to the Board of Governors, I think you'd be in violation of the OPMA if that's what your notice said, but now you are acting outside of your notice and beyond what the framework for that meeting is in terms of notice. Also, it would then raise, so for example, budget and audit, the chair of the Budget and Audit Committee is the treasurer. The treasurer is not the president. The president presides at Board of Governors meetings. And only then may others convene that and preside if the president is not there. So again, those are not the same animals. So I don't think they require a dual notice. I think that would only come up if, in fact, for other reasons, the executive committee decided it was going to have sort of this joint meeting. And again, you would notice it. And how can I? So, for example, I think when the foundation meets, we've noticed that the foundation is meeting, and we actually declare that we're not now the Board of Governors, we're now acting as the foundation. I think we turn the gavel over to the president of the foundation. They do whatever, and then when they're done, it comes back to the Board of Governors meeting, and the gavel is then again given to the chair. So,
Thank you, Parliamentarian Stevens. I have Treasurer Clark, followed by Governor Knight, followed by Governor Gerbicki. Treasurer Clark.
Sure. Thank you, Kyle. With this, I mean, this makes sense to do. It's about fairness, but it's also about, we had an amazing year last year with the 8. I think it really adds to the when we speak and we have people there with it works out really well. And I don't think it'll be an issue with the eight of us there, because we don't take a final action there. We make a okay, so we send things here for that. So yeah, thank you so much, Kyle.
Thank you, Treasurer Clark. Governor Knight.
Thank you. I just in general discussion on this issue, I would like to pose a question of whether there is another option that is less severe than amending the bylaws. And so, President Schetti, I don't know if throwing out a suggestion is appropriate at this time.
I don't know. Go ahead.
Okay, so here's my understanding of how we got here, and please correct me if I'm wrong about this. President Schetti believed that there were 8 people on the Budget and Audit Committee, and he appointed 8 people, 8 governors to the Budget and Audit Committee, then learned that actually the bylaws provide for a 7-person committee, and then President Shigetti had to remove 1 person. He removed Governor Higginson. Governor Higginson still wants to be on the Budget and Audit Committee. My question is there someone that's still on the Budget and Audit Committee that would be willing to wait until next year to be on the Budget and Audit Committee, or step aside for this year and keep it at 7 so we don't have a quorum meeting with Budget and Audit? Did we explore this idea of whether or not there was a volunteer to step forward first?
Well, okay, so let's back up a little bit. It's the president's prerogative to make appointments, and part of the responsibility there is to make appointments that are in the best interest of the organization. And I felt that's what I did. I think it would be a little unfair in public session to suggest anyone should relinquish and volunteer their spot now. So I do not want to do that. Whether somebody or not volunteered or not, I'm not going to get into those discussions.
I'm not asking for, the last thing I want to do is put someone on the spot in public session. What I'm trying to discuss is there's a lot of background here that led up to this, and I'm wondering if there's a option that's less severe than amending the bylaws. It sounds to me like we haven't explored that. Maybe exploring it would result in the exact same place we are. Everyone wants to be on Budget and Audit. That's certainly a story I've heard. I don't understand that. I don't want to be on Budget and Audit, but I understand a lot of people do. So I just don't know if all those folks that you placed on the committee are intent on being there. So that's the only question I have. It's not something for discussion in a public meeting, but this is a first read anyway. Perhaps we don't need to reach to the second meeting of whether we vote on this if the issue is solved in the interim.
Appreciate that, Governor Knight. Governor Grabecki.
I move we approve the amendment for first reading.
Thank you, Governor Grabecki. Do we do that?
We don't normally do it. I mean, I think if you're just saying, I think it might be a little confusing because we're not really taking action. We're just hearing it, asking questions, and then you'll take action next meeting.
All right, I withdraw my motion.
Okay.
Thank you, Governor Grabecki.
Mr. President.
Yes, parliamentarian.
Yeah, and I just wanted to, I understand where Governor Knight was coming from. So as the bylaws read currently, okay, if I understand the fact pattern, you made an error. You appointed too many people. And so a part of that within your authority would be to correct the error yourself, to bring it down to 7. Now, which 7 is another thing. But at least the overarching question, the only reason I'm kind of stepping in to make a suggestion is I would hope that we would not always move to make corrections by bylaw amendments, because that becomes a real problem that we set bylaws and then we, because of certain circumstances, make a change to the bylaw to handle that circumstance. And I'm not sure that's what the body should be doing in terms of correcting things when the bylaws are fairly straightforward.
Appreciate that, Parliamentarian Stevens. The error has been corrected. There's currently 7 members of the Board Budget and Audit Committee, so we are operating consistently with the bylaws. The question then becomes, if we amend the bylaws, can we return the Budget and Audit Committee to 8 members and still function in coordination and alignment with the bylaws. Governor Higginson.
Well, this is a difficult situation to have a discussion on, especially in a public setting, but I'm going to be as tactful as I can. And I don't know, maybe I should be asking for an executive session because this does bear on the investigation that's pending involving my remark at the June meeting. So before we go any further, I'm going to ask a general counsel if we should be moving to executive session to talk about the situation.
General Counsel Shanklin.
I don't. So executive session can be had for the reasons listed in the statute. And I guess I don't really know enough about what you intended to say to really understand whether executive session will be authorized under the OPMA.
General Counsel Shanklin, if I read the RCW that might apply and then ask Governor Higginson if she thinks that does apply, would that work?
Yes.
And then we could go into executive session and then we would hear what the issue is and then you could make a determination whether that fits within executive session.
Can I just interject something while Julie's on the spot and thinking? I mean,
Sure.
I think Julie's job is to give advice. It seems like it's appropriate to provide the statutory definition, allow Governor Higginson to say whether or not she believes it's appropriate for executive session. Once you get into executive session, I think General Counsel Shanklin could give advice. I think it's ultimately, I believe it's probably the board has to decide, is this an appropriate use of executive session or not? And you all are the ones accountable under the rules. So
that's what I was suggesting.
Yeah. Okay.
All right. Well, why don't we do that? I'm going to read what I read earlier to get us into executive session. RCW 42.30.110, little I to little I on my form says, to discuss with legal counsel representing the agency matters relating to agency enforcement actions, or to discuss with legal counsel representing the agency litigation or potential litigation to which the agency, the governing body, or a member acting in an official capacity is or is likely to become a party when public knowledge regarding the discussion is likely to result in an adverse legal or financial consequence to the agency. Legal counsel will be present for the executive session discussion as required by the statute. No final action will be taken in time. So Governor Higginson, does that, in your opinion, meet the definition of the questions and the comments that you are prepared to make?
I believe it does.
Okay, so then let's get into executive session. It is now 3:36. Do I have to read this again? I have to read this again. Okay. The board will meet in executive session beginning at 3:38 p.m. as permitted by RCW 42.30.110 to discuss with legal counsel representing the agency matters relating to agency enforcement actions, or to discuss with legal counsel representing the agency litigation or potential litigation to which the agency, the governing body, or a member acting in an official capacity is or is likely to become a party when public knowledge regarding the decision is likely to result in an adverse legal or financial consequence to the agency. Legal counsel will be present for the executive session discussion as required by the statute. No final action will be taken in executive session. The executive session will end at, that's a good question, about 4 o'clock, and the board will resume public session at that time. If the executive session is going to be extended, I will make a public announcement at the time the public will begin. On reconsideration, perhaps we should make it The executive session will end at 3:45. And then if we decide that we need longer, we will do that. How does that sound like a better approach?
How about
3:40. Sorry, I was just gonna say 3:45 seems awfully short.
Well, if we decide right away that this is not appropriate for executive session, then we'll be back right away. And so I'll just have to pop back in at 3:45 and do an extension, and then we'll know how much time we need. Okay, so let me read that final part once again so that there's no confusion. No final action will be taken in executive session. The executive session will end at 3:45 and the board will resume public session at that time. If the executive session is going to be extended, I will make a public announcement of the time that public session will begin. We'll now go into it. We are in the process of coming back. However, our last announcement was to come back at 4:15. We are back early, but we cannot restart until 4:15. So we will be taking a 18-minute break, and I will see everybody at 4:15.